my name is Mei Yuan. I'm from China and living in Wuhan, Hubei province. Now I am an MBA student. Let's talk about the student athletes getting compensation today. When Marky Emmett succeeded Miller's brand as the president of the NCAA, two of his objectives were to simplify the roller gambling into collegiate athletes and to create legislation the membership would adapt to permit small stipends for student athletes. According to CBS, published in 2013, NCAA President Mark Emmert hopes to unveil a new stipend plan in April. Among the plan's options, according to Emmett, athletes applying for monthly free application for federal students and giving universities or conference discretion over how funds are allocated, calculating stipend payments based on family contribution. Pay for college athletes has always been a controversial topic. Recently, California Governor Gavin Newsom signed the Fair Pay to Play Act into law. The bill permits college athletes in the state to hire agents and be paid for endorsement. For the first time, student athletes will be allowed to promote products and companies and financially benefit from their college sports activities. The new California law, which is scheduled to go into effect in 2023, would now allow them to reap the financial reward for their athletic abilities. According to Dana Husinger, Indianapolis Star published at October 3, NCAA President Mark Emmett says a fair play to pay Act turns students athletes into employers. There is a choice every high school senior who plays sports should have a mark, says NCAA President Mark Emmett. They can choose to be a college athlete or they can choose to be a professional. There is no room for both other voters to market and for all intents and purposes. Athletes become employees of the schools. Emmett said this is just a new form of professionalism and a different way of converting students into employers. Emmett said they may be paid in a fashion different than a paycheck, but that doesn't make them not paid. But according to CNBC published October 29, the organization's top governing board voted universally to allow college athletes to be compensated, so the NCAA's three divisions must still craft their own rules and detail the specifics. Student athletes must be treated similar to non-athlete students, must not treat as employees of their respective universities, and there should be a clear distinction between college and professional opportunities. The NCAA said in September, California became the first state to pass a law that would allow college athletes to get paid for endorsement deals and hire sport agents. Let's see a video.
Right, Kelly. So the NCAA just issued a press release saying that its Board of Governors is actually going to open the door now for its players to get paid. So they're going to start the process to enhance the name, image, and likeness opportunities. Remember, this is not getting paid from the college directly, but allowing athletes to get paid from outside external sources. Again, this is just the first step in what will take months, maybe a year and a half. They want these rules in by no later than January 2021 for each of the three NCAA divisions. So this is the first step, but it is a big step because remember, the NCAA had been pretty adamant that they did not want college players getting paid, and now they're saying, look, we understand the rules have changed, laws like in California have changed, congressmen are trying to put together new bills, we're going to go ahead and let this happen and watch for specific rules to actually come in the next few months. Kelly, back to you.
This is a huge U-turn. I can't imagine the ramifications. I don't even know where to begin.
You could have gotten paid when you were playing lacrosse.
Yeah, I don't think I would have collected much for that, but it's true. Everyone from Division 1 right down to D3 And you think that they're saying this could happen within about 18 months' time?
They're saying they want rules to get put in immediately, but no later than January 2021. And they're still going to have the working group of this board of directors will have its gathering feedback period at least through April. So that's still 6 more months to go. So again, it's the first step in a process.
So, how student athlete compensation would impact labor law, and how student athlete compensation would impact taxation. The NACC's 1950 reforms rationalize the recruitment, description, and subsidization of player talents in two cases in 1953 and 1963. States courts had that scholarship students injured or killed in the course of their athletic duties were actually university employers for works compensation purpose. The form of remuneration is in nature shaken by the prospect that courts might recognize college athletic as employees. The NCAA invents the non-ubiquitous watchword student athletes as a direct response to this legal defeat. They crafted the term student athlete, and some it was embedded in all NCAA rule and interpretation as a mandated substitute for such words as players and athletes. The term student athlete was designed not only to conjure the nobility of amateurism and the precedence of scholarship over aesthetic in the world, but to obfuscate the nature of the legal relationship at the heart of growing commercial enterprise. College athletes is a big business. If additional money is paid to players, it is likely that the school will attempt to exercise more control over them. Control, of course, is a factor used in determining whether an employment relationship exists. A job by a college scholarship, which include attempts begin to look more like a professional sport contractor that happens to include tuition fees, room, board, and books, as well as cashing competent. Under most definition, a recipient of this type of scholarship would be an employee. So, what's the labor law? First, according to works compensation issue of the business sports workers compensation law are state statutes in actor to compensation works order is stated. For job-related injury or death, regardless of fault. Second, the four Labor Standards Act (FLSA) provide that employers must pay their employers a minimum wage and overtime pay for hours worked in excess of the statutory work week. The FLSA definition of employer is exceedingly broad, but does have its limit. The Court of Appeals found a number of circumstances relevant in evaluating whether an employment relationship exists, including further expectation of compensation. Second, the power to hire and fire, and the third, evidence that an arrangement was conceived or carried out to evade the law. For example, Lamar Dawson played football for the University of Southern California, a member of the National College Athletic Association and the PAC 20 Conference. Dawson brought a class action lawsuit against the NCAA and the PAC 20, where his employers on the federal and the state labor law, the Court of Appeals had also doesn't receive the scholarship to play football. The NCAA or PAC 20 did not provide the scholarship, so this could not present an expectation of compensation, and Dawson could not consider this compensation. Similarly, Dawson could not demonstrate the NCAA or PAC 20 had the power to hear or fear him. Dawson agreed the NCAA and PAC 20 controlled the lives of student athletes because the organizations established rules for the athletic and academic schedule, living arrangements, athletic eligibility, permissible compensation, and behavior, among other rules. However, Dawson did not allege, nor did the evidence show the NCAA or PAC 20 actually held fair or supervised the student athlete. Finally, there was no evidence the NCAA rules were considered or carried out to evade the law. Dawson then agreed the labor of student athletes generates substantial revenue for the NCAA and the PAC. And that this factor should after the course analysis. However, the Court of Appeals had the revenue generated by college sports did not unilaterally covenant the relationship between student athletes and the NCAA and PAC 20 to an employment relationship, and the Court's progress analysis controlled the determination. The Court of Appeals also agreed with the trial court's decision to dismiss Dawson's lawsuit based on California law because state law and state court decisions sufficient exclude student athletes from employment benefit and did not consider student athlete an employee of their school. Dawson did not offer any authority that support his agreement that even though California law did not consider student athletes employers of their school, the student athletes can nevertheless be the employers of the NCAA and the PAC 20. And I believe that under the influence of the new law, I believe that the the definition of student athletes will continue to improve. For example, a certain percentage of subsidies are paid for students' insurance. Through these behaviors, athletes who are injury or killed during sports are generated. And Richard Burr believed that this scholarship, which are used to pay for college tuition, should be taxed as income, but only for student athletes who receive scholarship outside of scholarship. According to the workers' compensation, currently athlete scholarships are not taxable to be athletes based upon experience with graduate assistant. It is clear that if the stipend is added at least that portion of the scholarship would constitute taxable income to the athletes. This would also add the burden of withholding for income tax as well as for social security and medical. It might future provide fuel for this who advocate the general removal of the tax exempt status of collegiate athletes, providing the stipend could have general removal of the tax impacts status of collegiate athletes, providing the stipends could have an impact on evolutions of unrelated business income for NCAA member institutions. Tax college is inevitable, but after students and athletes are able to pay enough insurance premiums, a certain percentage of tax will be collected so that students will get more fair treatment.